everyone. I am Lauren Mello, President of the Naples Area Board of Realtors. I am proud to say that NABOR has been serving members over 70 years. We provide MLS tools and services, legal resources, political advocacy, market statistics, an array of educational opportunities. NABOR also has a long tradition of giving back to our community. The Naples Area Board of Realtors is a good example of how associations guide and protect their members, as well as make their communities a better place to live and work. Thank you.
We are community service. We are continuing education. We are resources to help your business. We are about our members. We are Orlando Regional Realtor Association.
There will be baseball, rock concerts, and yes, even large gatherings. One thing is for sure, life will eventually be back to normal. In the meantime, we want you to know that we're here for you. From your friends and family at the Broward, Palm Beaches, and St. Lucie Realtors.
What if I told you that a home buyer browsing properties online is most likely to work with the first agent they speak to? I bet you'd make sure you're responding to leads as quickly as possible, right? So, what if it could be done for you with Success Assurance from Boomtown? Acting as an extension of your team, our trained lead concierges will respond to your leads 24/7 in as little as 90 seconds and nurture them for up to a year. Communication begins and ends with a real person, in real time, in the real world. For real. And Success Assurance isn't just one concierge. It's a symphony of trained professionals, engaging your leads around the clock. Follow the conversations live and chime in whenever you want. You'll be notified of every qualification, and your lead concierge can even schedule appointments for you. With Success Assurance, you can do it all. without having to do it all. So start turning what ifs into done deals with Success Assurance from Boomtown. Any questions?
One of the incredible values of your membership with Florida Realtors is access to a free legal hotline. Attorneys who specialize in real estate law are just a phone call away.
That's right. Vice President of Law and Policy and General Counsel Joanna Watkins is here to provide a legal update with the very latest to keep you and your business in the know. And by the way, we're back tomorrow and again on Thursday with lots more to come from your Florida Realtors virtual convention. But right now, here is today's final education session and General Counsel Joanna Watkins.
It is such an honor and pleasure to come before you this afternoon and to present to you what we hope is vital and relevant and timely information to help you do business in a way that is better, faster, and stronger. You know, I don't think any of us anticipated 2020 quite like the one we got. But I will tell you that if there is a silver lining in the midst of this otherwise bleak cloud, it is the fact that we have, in this virtual world, been able to connect even more than ever before with our members. And so in addition to the more than 38,000 phone calls that we received into the hotline during the first 6 months of 2020, we have had an opportunity to connect with so many of you in Zoom platforms and WebEx meetings and things of that nature. And here's what's critical about that. It is like having 195,000 intelligence officers, you know, our own army of Captain Americas and Captain Marvels, Aquamans, and Hulks out there giving us real-time information about what's happening in the real estate industry as it's happening. So we are so grateful for all of the valuable information that we get from you. You think you're getting information from us on the calls? I hope you are, but what you don't realize is you're also sharing with us. So today we're going to bring you an agenda that reflects all of that great intelligence that we got from our very own intelligence officers. And without further ado, I am going to turn it over to Joel Maxson, who is my Associate General Counsel, and he's going to talk to you about web accessibility. Joel, take the floor.
Thank you, Joanna. And as the PowerPoint makes its way on the screen, just wanted to say it's nice to see you all. It's a pleasure seeing you virtually and seeing some familiar names, at least in the chat. My topic, however, is not going to be a pleasant one. That said, hopefully you'll find it insightful and you know, you'll have some knowledge about a current event. About 30 years ago, signed into law the Americans with Disabilities Act. So this has been around for a few decades. We're all fairly familiar with it at this point. If I can get the next slide. You've seen it so often that it probably blends into the background, and you would just kind of expect to see Braille on elevator buttons, handicap accessible restroom facilities, and then, you know, it's just different design structures built into the architecture of any building that is open to the public. Next slide, please. However, this as this kind of made its way through and we got familiar with how it works when it comes to office spaces and otherwise buildings that are open to the public, some lawyers got a little clever with it and said, well, wait a minute, does this go further? Could it go further? Could this broadly worded federal law also apply to websites? And they've been trying out these theories and testing them out in court since about 2014. Well, longer than that, but if you can see the trend line starting at 2014, it's been ramping up quite a bit. 2019, that was projected. It actually kind of leveled off a little bit, which is good. But one thing that is for sure, it's not going in the opposite direction. Next slide, please. And Florida, unfortunately, happens to be one of those epicenters. It's number 2 in the nation behind New York. Next slide. And if you want to know what it looks like, and by the way, I'm going to have 2 separate conversations here. They're all about website accessibility, making websites that are accessible for people with disabilities. However, the first conversation I'm going to make is this first wave, I guess we'll call them, ADA website compliance lawsuits, and they came against big companies. If you just kind of look through this, you'll probably recognize most of the companies: Beef O'Brady, Sbarro, Speedway, ExxonMobil, big companies. And the way these ADA website lawsuits came is they file the lawsuit, they get your attention, you know they mean business, and you have to respond. It's not something you can ignore because it's not going anywhere. And as a matter of fact, these cases, they've also shown their mettle, the lawyers bringing them, by continuing forward with the cases aggressively in federal court, the high visibility, complex litigation. Next slide, please. And as they did it, they're doing it based on theories, legal theories, interpretations of broadly worded federal law. So it remains a little bit unclear. Although so far, the ones that are having success are the plaintiff's attorneys, not the companies trying to defend and argue that we don't need to do anything here, that it's a website. And also, in addition to the courtroom success they've had, the Department of Justice indicated, take the broad position that these obligations apply to all websites. And they've said this for a while. They signaled final rulemaking, in other words, giving you some clearer guidance on what that would look like, but unfortunately, that has not yet happened. Next slide, please. So until then, we're kind of going with the anchor of the conversation, if you will. And the anchor is really centered on Web Contact Accessibility Guidelines. You can call it WCAG 2.1 level AA. What that means is there is this entire guidebook that says, here's what your websites need to do to be accessible. They have 3 levels. Level A is the easiest, double A is the middle one, and that is the one that, at least the case in our jurisdiction, the Winn-Dixie case, adopted as this is the standard. And there's an extra layer, the AAA, harder to get, takes a little more work, but I guess that's for the overachievers, not required. And stay tuned, stay tuned. This law may change in the future. I hope at some point we have clearer guidance that gives a lighter burden to companies, but until it does, these lawsuits have merit. And the conservative recommendation that we've been saying for a few years now is strive for WCAG 2.1 AA. If the person who prepares your website isn't able to do that, you may need someone to come in and play with it, tweak it, an expert. Next slide, please. So what happens with these cases? You saw just a whole bunch of cases on the screen. The vast majority of them settle. The company says, okay, I will improve accessibility. I'll pay what it costs. And as sort of an extra that goes to they went to the trouble of filing the lawsuit, I will also pay attorney fee and costs. So that's kind of what it looks like. Most cases are just settling. For the few cases that have gone to trial, although the outcomes are mixed, like I said, we're not seeing a ton of success on the defense side. Not much at all, actually. So, but some of the differences, if you go from jurisdiction to jurisdiction around our nation, does it apply to all websites? Well, we just said the DOJ thinks it should. Some courts say it should. Or does there need to be a nexus to the store? That's what the Winn-Dixie case kind of centered on. They said, well, this person wants to use this app to see the pharmacy information. This kind of ties to the physical location. As a matter of fact, it's an added benefit that everyone who's not disabled gets. They can confidentially enter their order and just show up and pick it up without having to kind of look over their shoulder and make sure no nosy neighbors peeping in. And they said, yeah, that's actually a feature, and this needs to be accessible to all. So they focused on the nexus for the Winn-Dixie case. Now I'm just kind of getting to the lawyerly nitty-gritty details after telling you it's still kind of up in the air. So let's go to the next slide. I'm going to shift gears now. So what I just described in very rough terms is the big lawsuits that are targeting big companies. But in the past few months, this is the part you may have heard about. One specific law firm, it's kind of out of Miami, at least that seems to be where the lawyer practices, and that there's only one name or face we can attach to it. It's the Portell law firm, Jennifer Portell, although it also claims to have a virtual office that's up in DC, and it claims to be a nationwide law firm. And by the way, has spread to other states since this. But this one particular law firm has blanketed the real estate industry and targeted many of your colleagues and peers, and probably some of you at some point, or someone you know, with a demand letter. And it's similar to what I talked about, but notable differences. It's alleging violations of the Fair Housing Act. So this is kind of a novel theory. This would be a new application if it did go to court. The lawsuits aren't filed. Remember how I said the ADA lawsuits, they get your attention. You have to respond. There's a lawsuit. You can't ignore that. The lawyers and the execs are going to be putting their heads together. This is a threat. This is sort of a letter that says, fix it, and by the way, call me. And if you did call, the demand will be to pay a small, comparatively small amount of fees, legal fees, whatever you want to call it. Basically, that's arguably less than it would cost to pay a retainer of an attorney, and fix it. So it's similar, but a little different. Next slide, please. So how have our members responded so far? By the way, it's not on here, but I encourage you to look up the recent letter from NAR, Counsel Katie Johnson. She did very recently publish a letter. I believe Joanna may get a chance to talk about it later, I hope. If not, take a look out for that. But in addition to that, because that's just more of a general on behalf of the realtor world, members have done multiple things. There are pros and cons to each of these. I wish I could say this is the right answer. Obviously, I gravitate towards the first one. Have your lawyer call or write. The advantages to that are you're going to get some insight on the legal landscape. You're going to get somebody who can argue on your behalf and not give away too much information, which is a lot of times a mistake people make. And so far from what we've heard, that's kind of been the end of it. Again, this is very early days. It's altogether possible that the lawyers who called and made her go away for now won't be a deterrent and the lawsuits will be next. I don't know. So, but that's one option. Have a lawyer call or send a letter. Option 2, call to settle and correct the issues. You know, we've been telling people get in front of this. Otherwise, there is some liability here. So just call, you know, get rid of this immediate threat and correct the issues, right? That's another option. That's certainly the direction we went when we designed our, I mean, although we didn't get sued or get a threat of a lawsuit, you know, we did address this with our new website, you know, and spent some money on it. Next, third, contact E&O insurance provider. We've heard anecdotally that, that perhaps they'll cover it because it's a Fair Housing Act violation. Fourth, if you wanted to, call to talk to the lawyer but don't agree to anything. And last, ignore the letter. I know there was, because I said this has been going on around the nation, I did see another association say, well, since there's no clock, there's no time, you know, you could ignore it for now and there's no penalty. Next slide, and the last slide for me is, what does compliance look like? Essentially, you've either hired somebody who's incorporated that into the build they do for you, or you've done it yourself, or you hire a company to audit and correct the issues. If you're interested about what that looks like on the tech side, there's a 50-minute video. It says 45. I did a real short intro, so that's the non-important part. Skip over that. Go to this. The tech people who helped us with ours did a very good job being practical, down to earth, and explaining ADA website and the WCAG tech side. So that's all I have on that. I'm going to hand it over to Maria Marchante. She is a fantastic lawyer who kind of started around the same time I did. She's full of warmth and wisdom. So please welcome Maria.
Okay. Okay. Thank you, Joel. Yep. My name's Maria Marchante. I have been with Florida Realtors since 2011, with a little bit off with some babies in there, but I'm going to be talking to you today about screening tenants with criminal backgrounds because while this is not new, it is an issue. So first, we're going to start with testers. What or who are testers? It is an individual. It's just a person who has no intent to rent or purchase a property. They're not going to rent your listing. They pose as a prospective buyer. Usually I personally hear it on the hotline more as a prospective renter of real estate. And the whole purpose is they are there to gather information. They're there to identify unlawful housing discrimination based on a protected class. Okay. So some background. Shockingly, at least to me, as I was digging into this isn't new. In 1991, the Civil Rights Division established the Fair Housing Testing Program, and it went live in 1992. The goal is to find out if a housing provider is complying with fair housing laws. So I didn't realize this had been around. You hear about testers, but I didn't realize it had been around for as long as it has been. Okay. So some examples of how testers are used is, the first one is probably the one that up until recently I had heard the most, which is a person with a handicap requests an accommodation. A common one is, oh, I have a service animal or I have an emotional support animal. We hear that regularly. Another example is a person with a criminal conviction asks whether that automatically disqualifies them. And that is what we'll mostly be focusing on during my little piece of this presentation today. And sometimes we hear about testers with various races or various national origins with other similar factors, similar financial backgrounds, asking for similar things to try to see if people are being treated the same. Okay. So what is a protected class? Under the Fair Housing Act, race, religion, sex, disability, familial status, national origin. There can be additional protected classes, which can make things confusing, honestly, and it's something that definitely comes up regularly on the hotline. Things like sexual orientation, gender identity, source of income, and as a side note, the most popular question I get about source of income is, oh, do I have to accept a Section 8 tenant? It can be an issue depending on whether or not that has become a protected class in your area. Age, and even actual or perceived status as a victim of domestic violence, dating violence, or stalking. Okay, testers and criminal history, which is the focus today for this piece. HUD interprets the Fair Housing Act to prohibit practices that have an unjustified discriminatory effect. So while criminal history is not a protected class, housing restrictions based on criminal history may disproportionately impact minority home seekers. The biggest takeaway that I grabbed from this as I was looking into this and researching this, and I think you should take away from this piece today, is it does not matter if there was an intent to discriminate. It doesn't matter. It's the effect of your actions. Also, there is a difference between an arrest and a conviction. The goal is to distinguish between criminal conduct that indicates a demonstrable risk to resident safety or property and criminal conduct that does not. Keep in mind, anybody can be arrested. The conviction is what HUD deems to be a potential valid reason to decline somebody. Okay. So, just like for the website accessibility, we have a serial filer. This is not the only person who is a tester in the state of Florida, but this is one example. Somebody else pulled this actual screenshot, but I went on Pacer, which is a federal database for federal cases that have been filed. And this one plaintiff has filed since September of 2018, 108 cases, 108. And when you look down the 2 full pages and into the 3rd page of the filings, it's all, again, it's real estate companies, mostly for this filer in the middle and southern district of Florida, although there's a few in the northern district. So it's something to know. You as a realtor can be a target, and you need to know what to do to try to minimize your risk. Okay. So what is disparate impact? It's confusing. It's a legal doctrine under the Fair Housing Act. A policy can be considered discriminatory if there is a disproportionate adverse impact against a protected class. So the whole goal of the disparate impact theory is to safeguard the right to a fair shot for everyone. Okay. So the question we always get on the hotline is, well, can I deny a tenant with a criminal history? And in typical lawyer fashion, the answer is, it depends. So in April of 2016, HUD, their Office of General Counsel, issued guidance on the application of the Fair Housing Act standards to use criminal records provided for housing, for determining whether or not to approve somebody for housing. There's a 10-page memo that they put out. In that memo, they reference that nearly 1/3 of Americans have a criminal record. That's a lot of adult Americans have a criminal record. So again, criminal history itself is not a protected class. But the issue that comes up is the disparate impact or unequal impact that using this as a standard can have on a protected class. So the whole goal of the Fair Housing Act prohibits intentional housing discrimination and housing practices that have an unjustified discriminatory effect against a protected class. So you'd like to think you're never looking to intentionally discriminate, but the second part, it can be fuzzier, right, in figuring that out. Okay. So what can you do? You need to take into account factors such as the context of the crime, the severity, the nature of the crime, the age of the individual at the time of the offense, how long it's been since the crime occurred, is there evidence of rehabilitation, and you need to treat each applicant on a case-by-case basis. But it's also really important to remember to treat people the same. Don't treat people differently because they have criminal history. You're looking to, the whole point is an even playing field. Okay. So NAR put together lists of do's and don'ts that I'll go through quickly to finish this up. So do create a tailored criminal history based policies and practices. Do exclude individuals based on criminal convictions that present a risk to resident safety or property. You can take that into consideration, and you should. Do consider the nature and severity of an individual's crimes. Do consider the amount of time that has passed. Did somebody have a DUI from college and they're in their 50s now and nothing in between? Should that be a reason for them to not be able to purchase or rent this property? Treat all applicants equally. The process should be the same for everybody. You should conduct individualized assessments that take into account the age at the time of the conduct, the evidence of good tenancy, before and after the conduct, and rehabilitative efforts. All of those are important things to take into consideration. As a side note, keep in mind that there is no black and white list of what is okay and what is not okay. So we are going with suggestions in creating your own policies and procedures, especially if you handle, you don't have to be a property manager of hundreds of properties for this to become a problem and a thorn in your side. This is something where you have one property that you're listing as a favor for a friend or a client to rent out their property, and this can become a problem for you. So you should always be knowledgeable and educated on this situation, but especially when you have multiple properties, it's just more chances for something to become an issue. So then NAR has also put together a list of worst practices. Do not use criminal history as a pretext for unequal treatment. Do not provide inconsistent explanations for denial of a tenant. Do not create an exclusion based on arrest records alone. Remember, an arrest is not the same as a conviction. Do not create an overly broad or blanket exclusion of any person with any conviction. This is what is getting people sued. It's so easy to prevent. Don't say no criminal history. Don't. The odds are not in your favor for a successful outcome. So do not use comparable criminal history differently for individuals of a protected class. Again, treat people the same. And last one is do not make exceptions for some individuals, but not others based on the individual's inclusion in a protected class. It's all about that baseline treating people equally. And next up, I believe, is Meredith Caruso.
Hi, everyone. Thanks for attending today. I'm going to talk to you about also fair housing to some extent, but with a little different spin in regards to emotional support animals. Obviously, this is a hot topic in the news. It's definitely a hot topic that we're hearing on the hotline. And it actually was a hot topic in our own state legislature based on a law that just went into effect in July, the beginning of July. One of the examples that we have here for you is our coffee barista who has this lovely duck you can see here. This duck has a name. Its name is Prima Donna. And Prima Donna was asked, the landlord was asked to make an accommodation. The landlord clearly didn't understand why this duck should qualify, etc. Long story short, with the assistance of HUD, they were able to get Prima Donna to stay. But this is an issue. I mean, as this article from the New York Times says, dogs, ducks, even insects are being asked to be considered as emotional support animals. Next slide, please. So real quick before we get into this, I have a lot of calls on the hotline where we hear, oh, well, am I subject to ADA or ADA? And let's walk through, because again, the ADA is not the same as FHA, okay? There's some big differences that I wanna make sure everybody understands. Okay, so for the Americans with Disabilities Act, the ADA, that is a public. It applies to places of public accommodation versus fair housing applies only to private places like homes or that are for rent or for sale. The ADA specifically identifies a service animal, and they say that that is a dog or small horse trained to perform specialized tasks. Whereas the FHA, as we just saw with Prima Donna, does not narrow down any definition as to what qualifies as an emotional support animal. In addition, ADA, again, there's protection regarding service animals, not emotional support animals. So an example is the grocery store could say, sorry, you can't bring your emotional support animal in here. But if you had, for instance, like a seeing eye dog, you would, as a service animal, be able to bring that in there. The FHA, again, is also covering, is where this is applying is based on the section where Maria had mentioned all the different classes that could be covered under here. The protected classes. This one is specifically under the disabilities. It's also interchangeably known as the handicaps. Federal law has been interpreted to allow that buyers and tenants live with an emotional, we call them ESAs, emotional support animal, if it helps treat an emotional disorder or disability. Again, the ADA is only discrimination based on disability, and the FHA has all the other protected classes, which are on the next slide. So again, fair housing, which Maria went on, disability, race, color, national origin, religion, sex, and familial status. Versus ADA, which is discrimination only with people with disabilities with regard to employment, transportation, public accommodations, communications, and state and local government activities. Again, you are, with regards to pet restrictions, I think I saw something pop up with regards to how does this apply with associations. They're subject to the same rules. So if an association says no pets, someone has an emotional support animal, it's the same process. They have to go through the same process. So, and again, housing providers, that would mean also cover an association if it's subject to their approval, have to grant reasonable accommodations in those instances in accordance with the law. Next slide. So it's a basic analysis here that if the tenant has a physical or mental disability that, and the law specifically states, substantially limits one or more major life activities, then the landlord or the association, if applicable, has to grant that reasonable accommodation. So that might include, if there's a no pet policy, like I mentioned, that doesn't apply to a service animal or an ESA. Can't charge a pet deposit for either type of those animals. Or saying, oh, well, we'll charge you extra rent or something like that. Some people try to get creative around the pet deposit aspect. There was a case, though, keep in mind, this may sound very tenant friendly. I think people like to use that term. However, there have been cases where tenants have been, had issues where, because again, you are still subject to the rules. So if you have a service animal or an emotional support animal and they say, hey, the area for you to walk this animal is over in this section of the area or of the common areas, and you have to go over there and you have to clean up after your pet. If a tenant doesn't do that, the tenant is subject to penalties. So it's not like they can just say, oh, well, I don't have to pick up after my pet and I don't have to follow any other rules in regards to the pet. So those are things to keep in mind. Next slide. So if the disability is not apparent, then the housing provider can request further documentation. So they could say, okay, can I get a letter from your physician, social worker, whoever it may be, in order to show that there is the need for the service animal or to make the accommodation. You can't ask, obviously, for medical records. That seems to be fairly straightforward, but we're putting that in there because you can't say, well, I need to see, your medical records showing what what the issue might be and how, for your records. So next slide. So there is the new law, as I mentioned earlier, that went into effect on July 1st. There's an article, and just so you know, the next few things I'm going to mention are all available on our website. I did see somebody pop up saying, wait, go back to that other slide. The thing you need to know is at the very end of this presentation, there's an email address. Write that down, email us, and we will email you the slideshow, just so that nobody else is panicking about getting the slideshow. We will email it to you if you want it. So this new emotional support animal law basically clarified what's already in federal law. It gives more guidance as to what is allowed to be asked for versus what can't be asked for, and also what a tenant should be prepared to provide. So this is something to pay attention to if you are not only representing landlords, but also tenants. Next slide. So here are the biggest takeaways from the new ESA law. So there's the statute reference, and what the biggest thing that to me stood out was, as a result, this law was primarily a result of a lot of people just showing up with some sort of online certificate saying, here's my, my certificate, my dog is my service animal, my dog is my emotional support animal, and then saying, that's it. This law clarifies that by itself, something off the internet, and again, it's anything like an identification card, patch, certificate, some sort of other sort of registration obtained by the internet, is not by itself sufficient information to reliably establish that a person has a disability or disability-related need for that ESA. So therefore, if someone just shows up with a certificate, the landlord or the housing provider has the ability to say, I'm sorry, I need something more, whether that's the doctor's letter, etc. If the prospective buyer or tenant has an ESA or at any point in time obtains the ESA. That's a big takeaway too, because sometimes we'll get calls to the hotline where they didn't tell us that we had a pet. We didn't know that they had this animal. Now all of a sudden they're saying that it's an emotional support animal. That's fine. You have the right and you can ask for that, but you can't say, oh, because you didn't have it at the beginning, now you don't have one or anything like. You still have to go through that process. So, and again, you're able to ask for determination of both proof of the disability as well as the need for the emotional service animal if it's not readily apparent. Another thing the law specifically says is if a person, and this is another thing we hear on the hotline, how many emotional support animals can one person have? Well, there isn't a cap, there just isn't. But however, a housing provider is able to ask for documentation specific to each animal that someone may come up with in regards to saying, this is my emotional support animal. Next slide. So Joel did a fantastic video summary talking about this emotional support animal. And again, this is available if you go to the news and media section on our website and then go to the video library. Joel's is right at the top where this talks about and walks through this new law if you want more details on that. Next slide. So of course, we get it. There is going to be abuse of the system. There's a huge increase in the amount of service and emotional support animals being claimed by buyers and tenants. However, understand with this new law, there is a penalty component for tenants. If they are providing false information or falsifying documents, it could be considered a misdemeanor of second degree, and they might have to do 30 hours of community service for an organization that serves persons with disabilities. So that's the conclusion of my presentation. And now I believe I'm turning it over to Marcia to talk to you about evictions.
Good afternoon, everybody. I'm Marcia Tabak, the Deputy Legal Counsel of Florida Realtors. And I have to say, I really miss seeing you all in person, and I hope everybody's doing okay. So I have the topic regarding evictions and the role of the property manager. This is rather complicated, so I'm going to try to do it briefly. But again, as Meredith said, you can have any of the slides you want from any of the presentations if you just contact us after this. So most of you know, after the pandemic emergency was declared, most evictions were off the table. And that was due to Governor DeSantis's order, his executive order, and also due to the CARES Act, okay? So now we are 5 months in, and I want to sort of recap where we are now. Currently, we are under Governor DeSantis's Executive Order 20-180. And this order is significantly narrower than the previous orders, okay? With regard to this order, the governor has told or suspended any statutes that provide for final action at the conclusion of a residential eviction. This particular ban only covers evictions based on non-payment of rent if the non-payment of rent by the tenant is due to COVID emergencies, okay? And the order defines a COVID emergency as the loss of employment, diminished wages, or business income, or other monetary loss during Florida's state of emergency directly impacting tenants' ability to make payments. So essentially, evictions can be filed. It is the final act of the court which has been told. So recognize that, and recognize that the eviction is narrow because it only now, the ban is narrow because it only now covers tenants who can't pay due to the COVID emergency. And the other thing to note is that this order expires on September 1st at 12:01 a.m. So we are all waiting sort of on pins and needles to see whether we have a new order, whether we have an expanded order, whether we have a contracted order. So we'll see. Next slide, please. In addition to being aware of our state executive order, I also wanted to call out a couple of other things to you. So before a landlord should go forward on an eviction, consider these matters as well. The CARES Act, which Congress passed months ago, required a moratorium ban, but that moratorium ban has expired. However, if you are dealing with a tenant who either has a lease or doesn't have a lease, but is in a covered dwelling, which essentially is a dwelling that has a federally related mortgage, you cannot evict them unless the landlord gives a 30-day notice to vacate. So that's still required, even though the moratorium is over. In addition, a landlord should be considering before evicting whether the landlord is in forbearance. In other words, whether the landlord has agreed with the mortgagee that the landlord is excused from paying its mortgage right now. They need to consider this because many of the forbearance agreements or laws regarding forbearance require that no evictions be handled during the forbearance. So be aware of that. Additionally, understand that eviction bans may still exist on dwellings which are federally insured, assisted, owned, or securitized. So we could be talking about properties where there's an underlying USDA loan, a VA loan, FHA loan, or Fannie or Freddie owned or guaranteed loan. And lastly, remember that a couple of weeks ago, President Trump signed an executive order. And although the executive order addressed evictions, it did not pose a new moratorium. But he did state that it is the policy of the US to minimize residential evictions. So we know that agencies are continuing to look at potential bans in the future. Next slide, please. So while we're talking about evictions, I wanted to recap a property manager's role, okay? So about 20 years ago, the Florida Supreme Court authorized property managers to handle certain evictions, but there were parameters, so I want to review that. The Florida Supreme Court said a property manager who is responsible for the day-to-day management of a property, which would include renting the units, maintaining the units, and collecting rents on residential property, could handle evictions if they had written authority from the landlord to evict, which was incidental to the management of the property. However, the authorization only covered evictions based upon non-payment of rent, and only if the eviction was uncontested. Next slide, please. If you are a property manager and you fit within the parameters we just discussed, what you are authorized to do would be to prepare eviction forms approved by the Florida Supreme Court. That includes drafting and serving a 3-day notice, drafting and filing a complaint for eviction, signing the eviction pleadings on behalf of the landlord, and drafting and filing motions for default, obtaining a final judgment, and writ of possession on behalf of the landlord. However, you cannot do any of this if the tenant contests the eviction, okay? So the authorization for property managers to go forward on those very limited cases, you know, for non-payment of rent with written authorization, if they really are in charge of the day-to-day operations, is only as good as the tenant does not contest. So as soon as the tenant responds to a complaint for eviction, the property manager needs to cease pursuing the matter, and an attorney or the landlord needs to continue, okay? Next slide, please. Now, there are limits to what property managers can do because not every situation falls under the facts that we just discussed. For example, if a tenant had a lease and the lease expired, but the tenant did not vacate, a property manager would not be able to move forward on an eviction because this action is not based on failure to pay rent. This action is based upon a tenant being in a place where they have no authority to be. In addition, a property manager has no authority to move forward on an eviction for an eviction based upon a tenant materially breaching the lease, like having guests too long or smoking in the place when they weren't supposed to, because again, those cases are not based upon failure to pay rent. Those are material breaches regarding terms of the lease. So if you are a property manager and you are dealing with a landlord who would like you to evict, we are suggesting to you that if the tenant is going to contest the eviction, for example, based upon non-payment due to COVID, we are recommending that you not even file the eviction and that instead the landlord or the landlord's attorney file the action. Next slide, please. So it's a fairly complicated situation because there's a lot of balls in the air. You got to stay flexible. I was at a seminar last week and one of the speakers mentioned that they were expecting somewhere over 800,000 evictions in Florida. So it's a big problem, and it's complicated by the fact that the orders and the policies are changing. So be on the lookout for that, and we will advise you when we know of any changes. I am suggesting to you that whenever possible, if you can negotiate the exit of the tenant without the necessity of going to court, it will be beneficial because the courts are clogged, and it's also beneficial for the tenant who really doesn't need an eviction on their record. The other thing I wanted to mention to you is there's nothing about any of these bans, any of the orders, any of these restrictions that excuse the tenant from paying the rent. They're just, the payments are just postponed for now, okay? And in addition, I wanted to just let you know that there's a new program where volunteer attorneys are attempting to help the legal services organizations around Florida in representing low-income tenants facing evictions. So the whole hope is to get people moved out if they need to be moved out in a place that works well for the tenant and opens up these properties for you all to lease for landlords who need new tenants that can pay. So call us with questions. And with that, I'm going to turn it over back to Joanna to do her bit.
So thank you so much. I want to talk to you really quickly before we get into questions about some of the information we have obtained from attending the meetings of the Florida Real Estate Commission and Florida Real Estate Appraisal Board. And I do want to just say this, you know, it is easy to have friends when everything's, you know, great and when times are good, but you really learn who your friends are when things are tough. And I will say that we as an organization have always enjoyed a great working relationship with the Florida Real Estate Commission, but we are very pleased that even, you know, as COVID, blindsided all of us, really, the Real Estate Commission and the team over there have been fantastic in being sensitive to the needs of our members. So in talking to you a little bit about licensing, I want to point out that as of, and I'm going to grab my glasses here because, well, you know, I had a birthday a couple weeks ago and I'm 34 and holding. Been holding there for a while, by the way, but as of May, we have 423,743 outstanding licenses in all statuses, all categories for the Florida Real Estate Commission. And the interesting thing about that is obviously that's the highest number of licensees that I think we've ever had here in the state. And in March, you see that we usually would have a drop between March and April. We saw a slight drop, but not the one that we usually see. And that is because the Real Estate Commission, as you know, they have extended both the March and the September renewal until December 31st. So we are really thankful to them for working with us on that. But 423,000 licensees outstanding as of May of this year. My screen is frozen. There we go. All right, so we have seen a decline in the number of applications in the midst of COVID. We usually have somewhere in the neighborhood of about 4,000 to 5,000 applications per month, as you could see, 4,700 plus in May of 2019, 4,200 in May of 2020. But we really felt it in April. April, right after COVID really took off, we were down substantially in the number of applications that we received for real estate, 2,300 applications or so. But again, look from April to May, we are rebounding as an industry in terms of the number of folks expressing a desire to come into the industry, and that bodes well for us, obviously, as realtors. So hopefully those folks will come into the industry and those folks will then come into the realtor family. I will say, for those of you who do not know, as of August 4th, I believe was the launch day, Pearson, the exam vendor for the Florida Real Estate Commission for actually all of the professions under the Department of Business and Professional Regulations, launched something called OnView, which is an at-home testing platform for the state exam. And so the good thing about that is there had been a backlog of folks who had submitted those applications and were unable to test. And now when you look at the most current exam numbers, we are back to the point of admitting over 2,000 new licensees last month to the industry. So we're almost back to pre-COVID numbers. Enforcement, they continue to see a pretty substantial number of complaints every month. As you can see, the numbers vary greatly. It just kind of depends, but they are pretty much on par for this year compared to where they were last year in terms of complaints received and investigated. Unlicensed activity, there has been a recent spike lately in the number of unlicensed activity complaints received. In February, they were down to 30 complaints received. As of May of this year, that had doubled, more than doubled, 63 complaints in May. So there appears to be a lot of interest in filing unlicensed activity complaints. But obviously, one of the things that they were very proud of is the reinstituting the audit and inspection program for brokerages. Not surprising, in the face of COVID, there have been little to no audits or inspections, and I suspect that will continue to be the case until it is safe for more face-to-face contact. So for right now, the audit and inspections are on hold. But I wanted to bring you some interesting information to kind of reward you for sitting through what may not be the most riveting information that you will receive during the course of this week. We talk about this all the time, how do you file a complaint? And so I wanted to give you some information that you can use, again, better, faster, stronger. How do you verify licenses? How do you file a complaint quickly if that's what you choose to do? And so for those of you who do not have this tool, I highly suggest you download the DBPR mobile app. It's very critical that you don't inadvertently aid or abet unlicensed activity. Remember, those complaints are going up, so you don't want to cooperate with a licensee who is not properly licensed. So download this app in real time in the field. You can go on, input the information, and verify the status of a licensee right there on the mobile app. It's available on both the Android platform and the Apple platform. So take a look at that. Complaints, sometimes we get calls on the hotline where folks say, Joanna, I want to know how to file a complaint, especially anonymously. And so this is a screenshot of the DBPR page showing you that you can go to this page, click here to file a complaint. You actually can file complaints online now. You used to have to do so in a hard copy format, but for real estate now you can actually file them online, and you can file them anonymously. Just remember not to put your name or any identifying contact information like your fax number or email on the complaint that you send, because the person that you file the complaint with will get the actual document, including the mail envelope or however you send it. They will get that information. If you would like to, interesting and transposed, but if you would like to report unlicensed activity, you may do so through the mobile app or at a 1-800 number. You can do that anonymously. So if someone is not going through the proper channels, getting licensed, doing it the right way, the way you all are, if you want to file a complaint, you may do so by calling the ULA report line. The number is here on the screen in red. And so finally, I decided to give you a special treat this year. People are always saying, Joanna, what about that naughty list, right? The list that used to come out, that used to get mailed. And I'd say it's still there. You just got to go online and you got to look at it, right? And so I'm going to show you how to get to it because people always ask me about it. So it's called the Disciplinary Activity Report. And this is the Real Estate Commission's homepage. If you go to the homepage, here you see this green block. At the bottom, the last option is Disciplinary Activity Report. If you click that, you will see this screen come up. They have the PDF version of all of their discipline since 2006 archived on this site. And so you can click, you say, hey, I think that guy got in trouble, a couple of years ago. I heard that he got suspended, and you want to find that. If you want to, you can search by his license number and look for his discipline associated with his license. Or if you just want to see everybody in 2018 who was disciplined by the Real Estate Commission, you can do that too. Just as an example, this is how it looks now. I hope none of these folks are in the room. I'm sorry if you are, or virtually in the room. But this is what it looks like. I went back to 2009 because I thought that might be safe. It gives you the city, the final order number, the name of the person, and a summary of the violation and the actual discipline that was rendered against them. So that is how you get to the naughty list for all of you who've always wanted to know. Now, that's all we have for you today. We have a few minutes left and we would love to answer your questions. It appears that we're probably not going to get to all of the questions because I see lots of them in the chat. I see lots in the Q&A, but let me tell you this. We write Q&A for Florida Realtors magazines, for the legal news. The great thing about the questions we don't get to is it gives us, again, that real-time intel on what we need to write about. So if we don't get to you today, we're certainly gonna take all of this information and digest it for possible FAQs for some of our media resources in the coming weeks and months. So let's see what we have in Q&A first. Will you have access to the slides? Absolutely, you will have access to the slides. You can email us at the website on this last screen that I had up, or you can download it from the app, from the Florida Realtors Convention app. It's posted there as well. Does the person have to disclose the pet when submitting the application for approval? Meredith, I'm assuming they mean the emotional support animal. Do they have to disclose at the time of the application? You want to take that one?
Sure. There's no law that requires that, but here's the thing. This is usually how this plays out. So the question I always say is because there just aren't any rules per se that say these are the steps you have to follow if you're screening a tenant versus if you're, because there's nothing that requires, quite frankly, a landlord to even screen a tenant. If somebody walks in off the street and I want to rent my property to them, I can. I don't have to check anything. That wouldn't maybe be the wisest choice. However, if you do choose to screen your tenants or you have rules regarding buyers like an association, you know, the questions that you come up with could vary greatly. So if you're asking, you know, on your application, do you have a pet? Someone could be clever about it and say, no, I don't have a pet, because service animals aren't considered pets under the law. They're more like an assistive device, like a wheelchair or a cane. The next question might be a good idea to add this to the application. Do you have a service animal of any type? I'm not sure how someone could get around necessarily answering that, whereas they might get creative in terms of the pet. At the end of the day, I would say, of course, you should be truthful and in your answering. No, they don't have a pet, but they do have a service animal. Because inevitably, if there are rules or regulations coming from an association or a landlord with regard to the presence of an animal in the property, this is going to become an issue. So to me, to address this head on is probably the smartest avenue.
So I see a question here, and I'm going to throw it out to Meredith or Joel, because this is one we get on the hotline often. Can landlords put a limit, a weight limit or breed restriction on an emotional support animal? Meredith or Joel, one of you want to take that?
I'll do it, Joel. So can you have, there are weight limits and you can put a weight limit on pets, but that doesn't apply to a service animal. That's, again, if you keep in mind, a service animal is not a pet. It's like an assistive device, like a wheelchair or cane. Is there a weight limit for a cane or a wheelchair? No, in theory, it's the same kind of concept. No, there isn't. That can't be taken into account with regards to approval or denial of that service animal, the weight limit.
So I see another question that deals with deed restrictions. Marcia or Maria, maybe Marcia, I don't know if one of you want to take this. Do deed restrictions stay with the property forever? For example, use of property as a residence, not a business, such as Airbnb. Marcia, do deed restrictions, or Maria, stay with the property forever?
That is one I think we should get back to. There are ways to remove them if they're unlawful, like the deed restriction that said we couldn't have, you know, some minority. Those become unlawful, and then there are ways to remove them. There are, and Joel, I see you want to add in. Go ahead.
I was just going to say, there is something called the Marketable Record Title Act that is extremely complicated. And I don't think we could do anything other than this than say, yeah, that's kind of what that might do. Exceptions apply, but
I would suggest that we just get the name of that person, then we can contact them.
All right, perfect.
It's a complex question for sure.
Yeah.
That's a great answer. All right, so I see something here about the widget for fair house or for web accessibility. Joel, do you want to weigh in on the widget?
I can as best I can. So my disclaimer, I know I kind of shortchanged the tech side of it. That's because I don't know tech. From what I've read and heard and seen from at least sources we trust, the widgets will and the scans will get you part of the way there. They'll get you part of the way there. So they might be a helpful tool for you if you don't understand like how people with vision or hearing or even physical disabilities might have difficulties interacting with your website. These can give you a picture of the types of modifications you need to do. So they are and can be a great tool, an education tool. As far as what we're hearing from, if you want to be, compliant or make it to compliance, it's just hire an expert or make sure the experts have designed it. So that's kind of where we are on that. And again, that's my 2 cents version as far as what I've heard, read, seen.
Well, y'all, we are at 6:15 by my clock. I want to point out a couple of things for you. In the chat box, you have a link to the PowerPoint. If you want to go ahead and grab that link right now, it's posted about 6:03. So if you're interested in getting a copy of the PowerPoint right now, you may do so by accessing that link. I want to thank you all so much for taking time and what actually is after hours from a traditional business sense, joining us today. I don't know how many, it looks like we have 377 participants. So thank you all so much for taking time to join us today. We do not take that lightly. On behalf of all of the attorneys and employees of Florida Realtors Law and Policy section, I thank you. And please stay safe and enjoy the rest of this amazing convention.